You're listening to the Valley Labor Report with David Story and Jacob Morrison.
We've got Brandon Magner on the line. He is a labor lawyer. He is the author of the blog Labor Law Lite on Substack. That's spelled L-I-T-E, Labor Law Lite on Substack. Brandon, thank you for taking the time to join us today. I appreciate it.
Yeah, thanks a lot for having me, Jacob. David.
Yep. So like I said, Brandon has a really good blog. Everybody should subscribe. It's on Substack.com. The title is Labor Law Lite. He's been doing a lot of analysis on the PRO Act. It's been the topic of a lot of conversation online, and so folks should definitely check it out. And he wrote a really good article about what the Amazon union election would have looked like had the PRO Act been law. So that's the big thing that we wanted to talk to him about today. But before we do that, could you just give us a refresher on what exactly the PRO Act does?
Sure. So the PRO Act, the Protecting the Right to Organize Act, is sort of the latest attempt, but the most comprehensive ever, in my opinion, attempts at labor law reform from a pro-union perspective. Labor law reform has been attempted many times before, trying to repeal right to work in the 1960s, trying to enforce a ban on permanent striker replacements in the 90s, card check in the 2000s. But the PRO Act's the first real, in my opinion, comprehensive attempt at changing the law to actually benefit workers. Since it's sort of the answer to Taft-Hartley, in my opinion, from the 40s. The PRO Act, it changes, and what I mean by comprehensive is it doesn't just attempt to fix one little hole like right to work or card check. It attacks the deficiencies in being able to organize. It attacks the deficiencies in being able to, once you have a union, being able to secure second, third, fourth contracts through giving more economic weapons to unions to use in negotiations. It cracks down on a lot of unfair economic weapons that employers have been able to use over the years. And it beefs up the remedies that the NLRB can use in cracking down on employers. And also it expands the amount of employees that could come under coverage to the NLRA through changing the employee versus independent contractor test. So in my opinion, that attacks basically everything that labor law has been missing over the last several decades and which unions need. And I think unions need every single piece of that to really be able to comprehensively change the way that the labor movement organizes and builds power in this country.
Yeah, you mentioned that it's not only kind of the most comprehensive pro-worker bill, it's really the first pro-worker change to labor law. I mean, really, since the NLRA, right? I mean, every other change to labor law has been something that the employers have been pushing, bosses have been pushing, that has hurt workers' ability to organize and to fight for better wages and working conditions on the job, at least nationally, right?
Correct. The only real comprehensive changes to labor law have been, you mentioned the NLRA itself, but the Taft-Hartley Act in 1947 and the Landrum-Griffin Act in 1959 are the only real major changes that have ever been made to the NLRA, and those were seen as universally anti-union, pro-employer changes to the law. And just to tie this into the current political landscape, every attempt that I spoke about of trying to change the law in a pro-worker perspective all died in the Senate because of the filibuster. All of those votes, all of those laws at one time had 50 or more senators that were on the record saying they supported it, and all of them died because you couldn't reach that 60 number. So I know that's we're not really talking about necessarily the politics today, but if you want to get the PRO Act passed, you got to get rid of the filibuster.
Yeah, well, the politics are important because we're going to rely on legislators and senators to enact that. And I think it's important to point out when you use the word attack early on, it's not really an attack. It's basically equalizing the playing field, because the playing field has been slanted so far towards corporations for the past 80 years that we've been fighting with both hands tied behind our back.
No, absolutely. it's not it doesn't automatically enroll everybody in America in a union overnight. Maybe that'd be a little unfair. I don't know. Like, I don't think it'd be the worst thing in the world, but it does give you a chance. It gives you a chance to actually enforce your rights without the employer basically being able to deny them at will.
Yeah.
And you've seen, and I don't want to say that doesn't mean unions haven't been able to succeed ever under the NLRA, but it's incredibly difficult. And as we're going to talk about with Amazon, it basically requires like the whole country to come together to get behind you and to even have a chance, it feels like, right?
Yeah. Well, let's talk about Amazon then. Amazon, everybody knows, we've been following it pretty closely. We've talked to workers, we've talked to RWDSU members outside of Amazon, we've talked to staff organizers, elected officials in the union here on this show, and they are organizing in a situation without the PRO Act. Talk to us about some of the issues that they've been having with labor law in this country and how it would have been different under the PRO Act.
Sure. So the Amazon union election, I think anybody who follows these elections and knows anything about labor law is not surprised at all about 99% of what's happened. It's really the blueprint employer playbook that's been run for about 40 years. It's use captive audience meetings overwhelmingly. That's legal under the law currently, and it's used in studies show it's used in over 90% of union elections, and it has been found as to be the most effective weapon that the employer can use against unions, because unions have no equal right to under labor law. That was a former ruling. They have no equal right to speak to employees in sort of a massed assembly like that. Meanwhile, the employer can do it every day, 4 hours a day, whenever they want, and just propagandize their message. And that's incredibly effective to people who are on the fence or who just aren't getting a lot of information from the union. And, respectfully, if you work 12 hours a day in an Amazon plant, maybe you don't want to go home and think about work more. So being able to talk to them at work is incredibly effective. But it's also just, it's being able to, as we saw, the stage was really set with the actual pre-election hearings, where Amazon was able to either force the union into a choice of either we're going to stall before we even get to an election, because we're going to try and inflate this bargaining unit that you've petitioned for as much as possible. We're going to hold hearings for weeks, months on end about what each of these job descriptions are, whether they fit, how they fit in with the other jobs that you've petitioned for. And it would have taken a long time. So they forced the union into a Hobson's choice of, okay, do we inflate the unit and have to organize far more workers than we expected, or do we wait months on end, let all the momentum of this union organizing drive die, and let them be able to do captive audience meetings for that entire time? So I guess I'll tie that into how the PRO Act would change things as one.
Yeah, well, let's talk about that. We'll talk about that here on David. If you could click MTJ Start Next and start, we're going to go right to a break, and we'll pick that up on the other side of the break, and then we should be good as far as the
all workers deserve
as far as everything. So be right back. Welcome back to the Valley Labor Report. My name is Jacob Morrison, here with my co-host David Story. On the line, we've got Brandon Magner, author of Labor Law Light on Substack.com. Thank you very much, Brandon, for sticking with us through these technical difficulties. We appreciate it. We were talking about how these anti-union meetings are really effective, and really, you didn't mention this, but you mentioned that they're unfair, but really they're, in my view, coercive, by their very nature of being on the clock, being given by people who have a supervisory role. But I've talked to conservatives about the PRO Act and how this will make these mandatory anti-union meetings illegal, and they say that's anti-free speech. That's basically the kind of that's cancel culture kind of thing. I think that's silly. How would you respond to that?
Well, I'd respond by first saying that was once the NLRB's position, is that unfair labor practice. Captive audience meetings were an unfair labor practice because they were coercive under Section 8A1 of the NLRA. That got overturned because of I think that the NLRB eventually under the Eisenhower administration bought into that free speech argument. And it became such a mainstay in labor organizing drives that I think no one's really tried to go back and uproot it. But that's not a radical position at all, and that's not at all a guaranteed position, or that's not at all a guaranteed outcome. That it is I don't know, maybe they're making it first violates the Constitution or something. But really, you can regulate all sorts of things that employers do in the workplace. Otherwise, OSHA is unconstitutional. But there's no guarantee that, or really, the labor law should not allow employers to take all their employees into a room and force them to listen to any message for 4 hours at a time. Mm-hmm. I think you're right that's a asymmetry under the law, and I think the PRO Act recognizes that and makes these captive audience meetings an unfair labor practice as they once were. And that's important because, one, that takes away the employer's main weapon that they use in an organizing drive to get out their message. But two, the PRO Act changes the calculus for how it arrives at when an employer should have to issue a bargaining order for committing violations of labor law during an organizing drive, by saying that if you commit any unfair labor practice or you otherwise interfere in an election too much that takes away employees' freedom of choice during the election, you have to bargain with the union as long as the union was able to demonstrate that at some point before the election, they had majority support within the proposed bargaining unit. Right. And that's extremely important because that puts the employer in a very strict, confined area of what they're allowed to do and say during an election. And a lot of their current methods are all unfair labor practices. So if you screw up and you try to coerce your employees, then you may have just lost the entire thing. And then now there's a union you have to bargain with. So I think that radically shifts how they approach organizing drives. And not only that, but they aren't allowed under the PRO Act. They wouldn't be allowed under the PRO Act to participate in the pre-election hearings that we saw that were so pivotal with Amazon. Mm-hmm. It takes away employers' standing, their right to participate in these hearings. Well, so from the employer.
Circling back to the unfair labor practices during an election resulting in mandatory bargaining with the union, like the union getting in. This is something that I had actually misunderstood for a long time. I thought that there was automatic card check in the PRO Act. That is not actually the case. And there was a lot of concern about, feigned concern, I guess I should say, about the preservation of the secret ballot. Mm-hmm. And that card check does away because it doesn't necessitate a secret ballot. That's bad. It's bad for democracy. It's bad. Whatever, they can be intimidated, and the idea that the union RWDSU can intimidate people more than Amazon is just it's silly, and I think people need to recognize that. But the PRO Act doesn't institute card check. It actually, more than this clause of the PRO Act, more than anything else and more than anything certainly proposed by Republicans, preserves the dignity of the secret ballot, because it says, like you said, if they show that there was at one point a majority support for the union and there were done unfair labor practices that could have coerced people into voting against the union, then they get the union because there was that majority support previously. And so it really preserves the process of the secret ballot and says, look, you've got a right through this process to an election and to a secret ballot. And if the employer violates that right, then we will believe the first thing that you said, which is that you want a union.
Right. I think you just summed it up very well. And I think that was probably put in there to take away a lot of employers' eventual arguments against card check or being part of the PRO Act. So, it's funny because a lot of them still think, I think from that erroneous reading of the law, I think they still think that there's card check, but you haven't seen the sort of overwhelming. When I remember the late 2000s when card check was a thing and you had ads being run all the time and just like, oh, they're trying to take away your right to vote, basically. And I think, who knows, maybe that's because of voting rights are so prominent right now in elsewhere in the political landscape, that maybe they wanted to keep this feeling of this election machinery still in place in the NLRB, because card check would have really done away a lot of that.
Right.
But I think you're right that it creates a good political argument for the PRO Act that it keeps this secret ballot provision in place, but it says that as long as that you get to still have the secret ballot as long as the employer doesn't blatantly violate the law in some way.
Right.
And then because at that point they kind of forfeit their right to have this process, because it's only there in place assuming that there's two good faith parties here, trying to pitch their message to the employees. But if one's going outside the law to do it, then why should they have the equal say in the arena? Right.
Yeah. And that's, it's a really good, I think, I even personally like this better than card check, because this says, look, it says, look, there's a secret ballot, and if you because the problem that I have with the way that the NLRB elections are done is that they allow the employer to gerrymander the unit. They allow the employer to commit ULPs as a practice, and why can they violate the law just as a general practice? The answer to that is because the penalties for it are so inconsequential that it can just become a cost of doing business, and so then they win the election by violating the law, and then the union's options are, okay, do we put the workers through another election, or do we just give up? And by saying, okay, the penalty for violating the law is that these workers who have already expressed a desire to have a union, they have a union. That's a real penalty, and that's going to set the stage in my mind for a genuinely fair secret ballot election. And I don't know. I think that sounds good.
Yeah, I mean,
absolutely.
I'll say one thing and then I'll digress, because I'm a big proponent of card check for the simple fact that without card check, it makes it gives the appearance that the union is a third party, and the at issue is. If you have card check, and if you have a majority of employees in that workplace sign a card, then it's over. In other words, pitting a union against an employer and bringing in a government agency is absolute. I can't say what I want to say, but it's absolute crap.
Right.
Because the employees are the union, and once they sign the cards, then it should be an accepted thing. Mm-hmm. Private ballot. I mean, this whole idea of a private ballot is horse crap. If the employees decide they want a union, then they're a union. Simple as that. But I'm not arguing against a PRO Act. I'm just saying. To make this sound like this is a great win, if we do get the PRO Act, I still think it's terrible. It's just barely equaling the playing field. Barely.
No, and I think that if you take from the union perspective, I think card check is the natural conclusion that you come to when it comes to the employer shouldn't be allowed to have any say, right? It should be the employee's choice. They come to the employer as a union, and they're saying, okay, well, now bargain with us. That's probably true. I think, though, the reason why you have this system, this election machinery still being used in the PRO Act is because the NLRA for 85 years has been using the rhetoric of industrial democracy. There's been a lot of good research and scholarship that shows that the NLRA has always been tied to, when people try to defend it, or when they pushed it through Congress originally, it was to create a system of political democracy ported over into the workplace. And so in that, and I'm not disagreeing with you, but I think that when you're working within those confines, the secret ballot makes sense rhetorically.
Yeah, we'll pick that up on the other side. Stay tuned. This is the Valley Labor Report.
Charge for the land. A population burned up, bled dry. The marginalized multiply and unite to fight. You make the world.
All right, folks, welcome back to the Valley Labor Report. My name is Jacob Morrison, here with my co-host David Story. On the line, we've got Brandon Magner, a labor lawyer, author of Labor Law Light on Substack. And you were saying that, at least rhetorically, the secret ballot it seems to be good, even if card check would be the optimal thing. And I would at least agree with you there, for sure. So the circling back to the captive audience meeting, somebody asked this in our YouTube chat, and I wonder how you feel about it. The right of response instead of outright banning captive audience meetings, because the issue again with captive audience meetings is not only that they are, they're coercive, but also that they're unfair, meaning that the union doesn't have that kind of unfettered access to the workers that the employer does, and so they get all this time to every single worker in the plant as a condition of employment. Conservatives hate that in some states paying representation fees can be a condition of employment, but hours and hours of your time can be taken as a condition of your employment during these union campaigns by the boss to fill your head with anti-union propaganda. How do you feel about a right of response instead of a ban on captive audience meetings?
Oh, sorry. Now that was attempted by the NLRB too back in the 40s and 50s when they dropped the approach to banning captive audience meetings at all. So that kind of shows you right there that the original ask was to ban them in general, and then they tried to make a accommodation by saying equal access. But I'm just skeptical that if you give the employer footing at all in this arena, I think that it just kind of amplifies the problem that's already inherent in the workplace, which is they have more power. Yeah, sure. If you give the union an equal right to have their own meetings, it's one thing, but the employer still is able to hold over the employee's head. Hey, I control your paycheck. I control your work schedule. I control your entire ability to work here, really. So it is powerful, I think, to give the union a equal footing. And, I much prefer that over the current situation where the union has no equal footing and the employer's allowed to do it at will. But I think that when you still mass employees into a room in the workplace, you're basically ratifying the current power structure that's already in place. Right. And it's in whether the employer's still allowed to say the same things or not. There's still the implicit understanding that he has the power here. And so I think not allowing him to even open the forum at all is more powerful, in my opinion.
Right. I agree with that. I think that the coercive nature of the boss in the workplace is really, even if you give equal time, it's still not the same. So I agree. I think a ban is better. Some other things that would be changed, and I'm wondering if the mailbox that was put on Amazon's property that both Amazon and the Postal Service are saying that they didn't put up. I'm wondering, and that the NLRB told Amazon, no, you cannot put a mailbox on your property for this election.
Correct.
I think that's pretty clearly an unfair labor practice. That act alone would institute under the provisions that we were talking about earlier, because the bargaining unit has showed majority support already. They would have won a union because of that unfair labor practice, right?
That's exactly right. And that's a great example because, first of all, I think it's an unfair labor practice, or it's at least interference with the election under current law. So I think if the union can show at all that Amazon had any access to this this ballot box, the union's gonna have a real good argument to set aside this election if they lose it. But that's the trap that we fall into, right? And what would be changed on the product is under current law, you can set aside an election and then have another go, spend a bunch of money to try and do this again. The employer can commit unfair labor practice to get the result they want and trap you in this litigation loop. And maybe one day you can get a bargaining order. But under current law, it's really hard to get that passed in the reviewing federal circuit courts because after 3 or 4 years of litigation, you've got the unit with a 30, 40, 50% turnover. And the employer, the courts have been, in the past at least, they've said that when there's that much turnover, that's no longer freedom of choice for the employees. You have to give them another election. So it's this kind of laughable idea of that you're protecting the employees by basically forcing them into this endless nightmare of trying to enforce their rights. But the PRO Act, like you said, would it'd be a very hard, strict standard of, you interfered, that shows not good faith, therefore bargain with the union, as long as they're able to show majority support beforehand.
Right.
And so it completely changes the calculus for the employer, where on the one hand, under current law, they can commit these unfair labor practices because the remedies are very weak. But under the PRO Act, it's going to be, if I commit any unfair labor practices, bam, I've got the union. So what's my incentive to commit the unfair labor practice? That's
exactly right. How else do you think the Amazon union election would have changed if the PRO Act had been law?
Well, like I mentioned earlier, so the pre-election process would have been completely different. The union would have almost certainly gotten its proposed unit for the election. It would have been the 1,500 that they originally wanted without the employer there to gerrymander the unit. Because he has no standing now under the PRO Act to these processes. He's not there to quadruple the voter list. So they would have had, they felt very confident about the unit that they petitioned for. So then, and then couple that with the Amazon really not having any incentive to commit unfair labor practices, then you've got a real good shot at the election. And of course, the PRO Act speeds up the processes themselves, so it gives less time for the employer to commit to do any sort of negative campaigning. And under the PRO Act, there's also there's the remedies, which are really important in terms of actual fines themselves. The current law does not allow the NLRB to order any sort of punitive damages at all for basically violating the law.
Mm-hmm. Yeah, talk to us. That is, that's just one more thing that I didn't realize the NLRB has no authority to issue punitive measures like in the form of fines.
No, zero. All they can do is they can restore, if you fired a worker for a blatantly unlawful reason, aka he was organizing a union. The most that they can do, that the Supreme Court has allowed them to do in interpreting the NLRA, is to restore him into the workplace with back pay.
Yeah.
And, maybe that has some symbolic power of you tried to fire him and he's back.
Right.
But the actual monetary calculation is fire the worker. Because what's the worst that's going to happen? I pay him back pay deducted under the law. Also forces the worker to have deducted from any remedial fines the amount that he made during the years that it takes for the NLRB to reinstate him. Any money that he made during that time at a new employer is deducted from his back pay. So the offending employer under the NLRA gets a discount for their unlawfulness.
Right, and there was a study or a story that just came out last week, a couple weeks ago, where somebody was reinstated, but from a firing for organizing from 2017, 4 years ago.
That's normal.
Yeah.
I mean, this type of litigation gets drawn out for years, and it's in the employer's best interest to do everything they can. And the worst that happens is they have to put up a little flyer on their bulletin boards and say, we violated the law. We're sorry. It won't happen again.
Right.
I mean, that's justice in America in the workplace.
So what are the new penalties that under the PRO Act, once it gets passed, what are the penalties that can be levied on employers?
So any unfair labor practice committed by an employer, each violation itself it's a penalty of up to $50,000. And then for repeat offenders, which is defined as any employer who's been found to have committed unfair labor practice within the last 5 years, it can be up to $100,000. And when you go back and when you go tally up unfair labor practices committed by employers in organizing drives and NLRB decisions, they can, each time that a supervisor says, if they surveil an employee, that's unlawful. If they say, I've heard the plant might close, that's unlawful. You find that this sort of this culture that's given around, that's built up around, just violate the law. What's the worst that can happen? That would rack up for employers millions and millions of dollars very quickly. And, for an Amazon, that's not a huge deal, but for for an auto parts store that has 15 workers and, tries to bust the union, that could be a huge penalty that really forces them to change their approach to, or really my perhaps rosy predictions are that for any medium or smaller size employer, you really are just not going to try and bust the union under the current methods, because it's going to be extremely expensive, and it is not that hard for the NLRB to prove these things.
Yeah,
right. The problem is it's hard. The problem has always been it's hard for the NLRB to actually do anything about it. It's not been that it's hard to prove violations under law. It's that the violations don't amount to much.
Yeah, and in most cases, you'll find that we constantly refuse to file ULPs because we know it's a losing cause. I mean, I was in an organizing drive a couple of years ago where the company came in and said, we'll give you 100% employer paid health care if the union don't go through. The problem is, we can file a ULP and run another election, but then who's the bad guy in that scenario? Because all of a sudden we're forcing the employer not to pay for your health care anymore, and it puts everyone at a disadvantage, and advantages the person that's actually breaking the law.
And every time you tell that story, I want to make sure everybody remembers that after the union threat was done, after the campaign was over, they lost their 100% employer-sponsored.
We're in the process of reorganizing them once again, but as all good things, anytime the employer makes you a promise, they're going to go back on it eventually, and they did. So,
that's a perfect description of why under the law. Why people always ask, why is the employer forbidden from making promises, benefits during an election? Because don't we want the employees to have better benefits? Isn't that the point? The union's there. He got the benefits, whether they won the election or not. It's because exactly like that, and there's Supreme Court case law that shows this, that the employer can just withdraw that the second they want once the union's defeated.
Yep.
That's a great illustration of it.
And we can't run in another election for another year. So the employees are sitting there on their hands going, well, we made a mistake. Well, but we told you were going to make a mistake. Right. But now our hands are tied.
Yeah. If you want to see what we're up to throughout the week, get our snide quips about the news of the day, then you should follow us on social media. We're on Facebook at facebook.com/The Valley Labor Report. We're on Twitter at Labor Reporters. I'm on Twitter at JacobM_AL. David is on Twitter at Radical Unionist. That's spelled RADICL Unionist. If you missed part of the show and want to go back and watch it later, you can search YouTube for The Valley Labor Report and subscribe to our channel. You can go back and watch the full show there, and we also clip segments throughout the week. We also upload the program on more than 11 different podcasting apps, so to see if we are on your listening platform of choice, go to thevalleylaborreport.transistor.fm/subscribe. We've got a website, thevalleylaborreport.org, where not only can you buy these fantastic union-made hats right here, they are made by a Unite Here local. They're fantastic. They're my favorite hat. Wear it all the time, even though it's a bit cheesy to wear your own merch. $35 with free shipping, and you get stickers. 2 stickers for free if you get the hat, and you can also buy the stickers by themselves if you just want a couple stickers. They're like $5. Pretty cheap if you don't want to. If you don't want to drop the $35 on the hat, we've got the stickers.
Union-made stickers.
Union-made stickers. All of our merch is union-made. And if you appreciate our work and just want to send us a couple dollars a month, that is very helpful. You can do that on patreon.com/The Valley Labor Report.